Right, I'm going to call us back to order. I think Judge Drummond is going to introduce his panel.
That one. Share screen. Well, good afternoon, everyone. It's a pleasure to be with you this afternoon for the Prime After Lunch panel. So my name is Mark Drummond. I am the chair of the executive director of the Civil Jury Project here at NYU. And I want to introduce my panel because there are two purposes to this. One is, Aristotle said, I must know you before I believe you. So I'm going to give you their credentials. In addition, it's going to be kind of a wallpaper of all the pandemic resources that this group has worked with. Because as you can see on the screen, we brainstormed this, and we're not going to be talking a lot about the pandemic, but we're going to be talking about the pandemic and what has transpired out of the pandemic and the things that we want to keep, the things we want to toss, and any new ideas. And the panel agreed that we should be focusing on three things: efficiency, access, and fairness. So I am going to begin, I think, if the clicker works. With this article out of the New York Times. I believe the date was December 2nd, 2020, only 9 trials in 9 months. Virus wreaks havoc on New York City courts. And quoted in this article is this sentence: one local courthouse in Orange County, California has completed 114 criminal trials since May, while the federal courthouse across the street has determined it's unsafe to hold any. And this is what happened. We became even more of a patchwork across the United States when the pandemic hit. Some courts pivoted very quickly to pandemic protocols, others did not. And I believe, and I don't mean to offend any other states here, but I believe that we have 2 of the states represented that transferred or that pivoted quickly. And those would be the states of Florida, the state of Washington, and I also believe the state of Texas was a leader in pivoting very quickly to different protocols. So let me, and again, I'm sorry about this. Here we go. So we have Judge Jennifer Bailey from the 11th Circuit in Florida, which is the 4th largest state court circuit in Florida. This gives you an idea as to all the resources that they have available to them in the 11th Circuit. In addition, you can see the drop-down list. I know you can't read all of those, but these are all the drop-downs where people can go for things like traffic, debt collection, domestic violence, and guardianship. In addition, she has been active in the Civil Justice Initiative, and she was on the Pandemic Digital Work Group creating virtual courtrooms in the state of Florida. And she managed the first hybrid jury trial, correct?
Yep.
All right. There's only one plaque on the Golden Gate Bridge that is not in honor of the people who worked on the Golden Gate Bridge. This is the plaque. It is a plaque honoring a 2-year-old girl who unfortunately fell to her death walking across the Golden Gate Bridge. This article here in San Francisco, here's the article in Chicago, and here's the article in the New York Times. And our next presenter, Doris Chang's firm, represented the family on this. So Doris is our practitioner here. She, her firm, the Walkup firm in California, is one of the premier personal injury firms dealing with catastrophic cases. She told me this afternoon that she has 2 Tesla cases. She just sent a subpoena to Elon Musk. She doesn't think he's going to respond to that. In addition, they handle cases such as the PG&E fire case and the Dupuy hip implant cases. So they have a lot of 7, 8, 9, 10 figure cases. In addition, she was the president of the San Francisco Bar Association, so she dealt with attorneys who deal with all different kinds of cases, including debt collection and mortgage foreclosure. We then turned to Professor Alex Mark of Wesleyan University, and she is going to give us the view from 30,000 feet. She is on a project now where she has analyzed over 26,000 court orders from the first year of the pandemic. If you read her materials, she quotes Richard Susskind, and I love this quote, asking rhetorically, is a court a service or a place? And we're going to talk about that dynamic. She has a book coming out in 2023 and is currently doing a project detailing the reforms and policy experiments in the state courts. We then turn to the state of Washington and Judge Matt Williams. He's been featured this article, Law 360. This judge is a Zoom trial MacGyver because he was one of the leaders in his court system of pivoting to the pandemic protocols. In addition, the Chief Justice talked about decisions from this point on being data-driven, and I believe that the state of Washington, perhaps the state of Florida also, is analyzing the data. One thing that we're anxious to get on the civil jury project is their analysis of whether remote jury selection increases demographics, that you get a better demographic with remote jury selection, and they are studying this very issue. I come down to our webpage at the Civil Jury Project just to show you the amount of resources. You can go on probably every court site throughout the United States, and there's a resource page. The problem is that there are some resources which are great, and there are other resources which are not so great. So what do we want to keep and what do we want to get rid of? I'll read this for those of you in the back. This is from the National Center for State Courts Quick Response Bulletin, Pandemic Perspective. Oh, I can't read that.
Has changed, perceived limitations.
Thank you. Processes that only a month ago were limited to face-to-face settings are now effectively being handled virtually. When the pandemic is over, newly gained capabilities and expectations will have changed the world. It will not be possible or even desirable to return to pre-pandemic norms. So I'm going to turn first to Professor Mark to give her thoughts on, I asked her to cherry pick the low-hanging fruit on the top 3 things that she has seen come out of the pandemic that you think we ought to keep.
Thank you. Thank you so much. And thank you to the center and to NYU for having us. This has been a really wonderful day, and it's just been really great to learn from all of you so far today. And as Judge Drummond mentioned in his introduction, I'm conducting a study on how these procedural reform projects unfolded in our state civil courts during the pandemic. And as he also mentioned, I know this is not a panel about the pandemic. I know this is not a day about the pandemic, but it's really hard to ignore its effects, especially as it implicates the question that's driving our panel, because many of the procedural reforms that contribute to the efficient and fair provision of justice in our state courts were pipe dreams, they were pilot studies, or they were completely off the radar of courts before March 2020. But the pandemic vaporized piloting and dreaming. It forced courts to address problems with process that were arguably already there, but were either perceived or otherwise further magnified by this public health emergency. So As Judge Drummond said, I've been asked to pick 3 procedural innovations that have increased access to justice in state courts that I've observed through my pandemic-focused research. This is very hard to do. So I won't call these my top 3 or my favorite 3 because I don't want to alienate a different innovation. They're all my best friends. They're all on the group chat. So it's difficult. But I'll briefly touch on the benefits and the challenges in institutionalizing remote hearings and broader access to electronic filing as my 2 friends. And I'll close by cheating with kind of a catch-all category, courts' willingness to engage in procedural reform experimentation, which has definitely been a theme throughout the day and throughout my own research. So first on the issue of remote hearings, allowing for hearings to proceed remotely or in hybrid modalities, it's obviously a major improvement in access to courts. There are some benefits both from a convenience perspective and also accessibility perspectives. So it offers convenience for both litigants and attorneys. We see lower default rates in dockets like those were mentioned earlier today. It reduces the need to go to a physical court for a brief status hearing for attorneys. But there's also some evidence to suggest that virtual platforms also make participating in court more accessible for those with disabilities. So there is some research to suggest that the ability to view live closed captioning is really, really useful for those who are hearing impaired, right? We don't have that in a physical courtroom. I will though tag that, again, live closed captioning is not a solution to all accessibility issues. There has been some conversation about using it to develop the written record, but if any of us have seen the closed captioning in a Zoom room, there are some funny mistakes from time to time. But there are a number of hurdles that we have to jump over in order to call remote hearings a reform that actually provides justice to citizens of a state. There are physical challenges. So as Justice McCormick showed the image of this old, probably on like a National Historic Register courthouse, not all courthouses are equipped with the technology necessary for court officers to host virtual hearings. Courts operate with limited resources, and we have seen plenty of examples of courts having to reconfigure their budgets or seek out external grant funding in order to bring these physical spaces up to speed. I was also speaking with some courthouse, like architect, interior design type folks over the last couple of weeks. And it's also very challenging to drill holes in historic buildings. So that's also something that's quite challenging because we'd like to continue to use these buildings and not just build more. Anyway, another type of challenge is the virtual challenge. So courts need strong and reliable internet connections to sort of continue to host these remote hearings, but so do people who are using courts. So what we've observed is courts adapting unused spaces to create physical Zoom rooms. So those who do not have internet access are able to use spaces in the court to join their remote hearings. And we also observe a lot of courts, while not providing Wi-Fi hotspot rentals, are at least making available on their websites lists of places where you could go to either access a Wi-Fi hotspot or rent a Wi-Fi hotspot. And then a final challenge in this remote hearing space is just the human challenge. So you can build as many tech interventions as you want, but we also need to be considering questions of legal and tech literacy. This was mentioned in the question and answer session with Chief Justice McCormick that, well, I just said it, but you can build as many of these tools as you want, but if people don't know where to find them or how to use them, they're not that useful. But taking all of these challenges into account, many jurisdictions have taken steps to formalize this pandemic-driven innovation. And I'll tag an open question for discussion that we've talked about as a group. There is this question about the degree of uniformity in how hearing modality rules are interpreted across courts. So I don't want to sit up here with judges and say that judicial discretion is not valuable. Judicial discretion is valuable, but there may be consequences to litigants if in one jurisdiction or even one courtroom within a courthouse that a judge has decided that all of X cases are going to be heard remotely, while the judge in the next room over who is hearing a similar docket says all of those cases are going to be heard in person. So I think that that's something we need to keep in mind. A second thing that I just want to talk a little bit about is electronic filing. So we observed an increase in the accessibility of e-filing during the pandemic. Many courts offered limited forms of e-filing before the pandemic, with more limitations placed on self-represented litigants than lawyers. But we do see how e-filing saves time and resources for both litigants and the court itself. But again, as we saw through the pandemic, e-filing means a range of things. Electronic could mean that you are sending PDFs to a court Gmail. It could also mean that you are uploading them to a portal. And in most cases, what a court does with those e-filed documents is they are either going to print them out and add them to the physical record, or they're going to manually, like by hand, transfer that information into a virtual file. So I'm hoping that Judge Bailey talks a little bit more about how CourtMap automates processes that are related to court files that are submitted electronically, because there is a lot of room for innovation in the automation of that information being transferred to the electronic file, because as the CourtMap process demonstrates, like it can trigger other court processes and create more efficiencies in the system. And again, of course, reforms that permit people to file documents without entering a courthouse, it's helpful, but it's only half helpful, because the majority of people who are accessing courts, self-represented litigants, they're not as familiar with the language present in these documents as attorneys. And they might not have the resources or the skills to navigate online systems successfully. Again, you can build all the tools in the world, but if you're not building it for your consumer base, nobody's going to use it. So we've also observed through the pandemic, courts experimenting with complementary reforms to e-filing. So we've seen new ways to provide information about how to obtain fee waivers, the offer of alternative forms of payment, especially for the underbanked. We've seen the conversion of documents to plain language, though in my research, I've also seen the use of more jargon in some of the pandemic orders. So you see a document from May 1st, 2020 that says if you are a party who is not represented by an attorney, and a document from the same court 3 months later that says pro se parties, like what, you did such a good job here, what are you doing? So e-filing systems can actually provide justice if they are meeting people where they are. And I'll just close by circling back to the question that's motivating our panel. How can we make use of procedural reforms to provide justice to citizens of the state? By arguing that this is a call to action in a lot of ways. I don't want to lose the energy of the last 2.5 years. This energy has brought a lot of movement to reforming court processes that we hadn't seen in the past 50, 100, however many years. The pandemic has forced this question. And as Chief Justice McCormick said in her remarks, no, we are not going to return to the status quo. But something that I think is even more challenging is the pull of the status quo of how we make choices about procedural reforms. I think that that's something that we should be really mindful of going forward, because the process is just as important as the outcomes that we are observing. And I will stop there.
All right. I'll give the panel a heads up that I will go bench, bar, bench. So Judge Bailey, you've been a judge for 30 years. You've always been involved in court operations. You helped your circuit through the foreclosure crisis in 2009, the civil initiative from 2013 to 2016, the justice initiative to reduce cost and delay. Have you ever seen anything like this? How did you and your court system pivot to it? And what would you like to keep?
Okay, so none of us ever saw anything like this. I will say, just to touch on a number of the topics earlier today, elected judge, elected in 1992. There's not a lot of difference between election and appointment in many places, depending on how politicized the appointment process is. So when you're looking at that, think about that. Yes, went through foreclosure, probably have tried upwards of 3,000 foreclosure cases in my lifetime. There is no better quality control apparatus in the litigation system than a trial, because it makes everybody put it all on the table. And I'll touch briefly on just foreclosures because this came up earlier today. My 30 years, right? I've seen a lot of water under the judicial bridge. I have, over the past 15 years, come to focus on what I call business process, court operations. And the reason for that is I got tired of arguing with judges, honestly. Every judge is an independent judicial officer, as they love to remind me. I am the presiding judge. I keep the elevators running for 25 judges in the civil division in Miami, Florida. During the foreclosure crisis, because timing is everything in life, I became the administrative judge, or presiding judge, as we call it, 45 days after the Lehman Brothers collapse, right? So our foreclosures went from 7,000 in 1 year to 90,000 just foreclosure cases the next. That was bad. So you can't judge your way out of a hole like that, right? It's going to take decades. So we created underlying business processes. And we tried to create underlying business processes in a way to satisfy the minimum requirements of due process, or put in more basic terms, so that we could explain to either my grandmother or the Miami Herald why we did what we did in every case. So we had every case reviewed that was submitted to us, reviewed for endorsements, affidavits, defaults, service. Now, if somebody lied on the service return, would we necessarily catch it? No. But all the minimum requirements were screened for. They were top sheeted, and then it went to a judge, and the judge could do what they wanted with that, because they don't work for me, they work for the taxpayers. But every case was screened for procedural adequacy and substantive adequacy before you could even get a hearing on your foreclosure. Those are just business processes. And people have talked about, how do you get judges to go along with that? Well, you know, the way you get judges to go along with a lot of these innovations is you say, dude, I'm going to make your life better on Tuesday. You're not going to have to screen through all these files, because I'm going to train the people to screen for you. You can sit there and watch me train them if you don't trust me to do it, or you can double check it, whatever you want to do. But you can create systems that have enough confidence and faith built in them that judges will trust them. And we can then achieve some uniformity, to go to the last point, so that it doesn't matter whether you get a judge that doesn't read anything or a judge that scrupulously reads everything. There's a minimum level of adequate substantive review in advance. I say all that because I think that the best opportunities for innovation are really in the business processes of the court. It's really hard to get statutory and rule change. You've heard the previous panelists just describe, working for years for these changes. But in the most part, in most courts, presiding judges and chief judges can change administrative process overnight. And frequently, it just has to do with reallocating resources. The other reason why this is all really important is, if we're going to take full advantage of technology, technology loves standardization. Technology does not love individual, like 25 judges, 25 different ways of doing things. You just don't have the resources to code 25 different procedures. So you can standardize things in the name of efficiency that appeals to people who might sit there and argue with you about other things, and make change occur in that way. So to Alex's point, we built this system in Miami called CourtMap. And it's called CourtMap. It's the court management and access platform, because, after Pacer, everybody had to have a snappy name. So what it does is, it is a single platform. It's the platform that judges operate on. It's the platform lawyers operate on. It's the platform self-represented litigants who opt in operate on. It functions exactly the same for self-represented litigants as it does for lawyers. We don't create additional burdens or barriers to set hearings for SRLs or the lawyer list, to use a better phrase, that lawyers don't have. It's exactly the same. There are connections for the lawyer list to be able to go to other spots on the website and get specific advice. There are on-demand video tutorials that are available 24/7 about how to use it. What it does is it takes every motion that you want the court to consider. It allows you to schedule your own hearing. It allows you to upload all the documents to a drag and drop system that so you can submit whatever you want to submit in support of whatever motion that you're setting. You can respond in there. Orders are generated in there. Proposed orders are submitted in there. Emergency motions are submitted in there. Courts can generate orders. They're automatically e-filed. You can look at the docket in there. And then during the pandemic, well, so that all existed pre-pandemic. During the pandemic, well, we pivoted. So we were open, we never closed because we had Court Map, we could keep working. We were completely paperless. So the paperwork kept getting processed throughout March and into April. By April 1, we were up on Zoom. We closed for 10 days. That was it. That was all the hearings that were canceled. Then we shifted over to Zoom. Here's a big interesting question. Yeah, it's great to be on Zoom, but how do they know you're on Zoom and how do they know what your Zoom hearing link is? So we had to figure out how to push the Zoom hearing link out. So we added to Court Map and built in within a matter of a few days, automatically scheduling the Zooms once we got the API so that the Zoom hearing would automatically get pushed out through Court Map to the service list. And that includes, here's your Zoom link, here's a reminder about your Zoom. And so that everybody gets reminders about everything. In addition, we added a text message you had to register, because here's the thing about text messaging. It really works well, but you have to know their phone number. There's nothing inherent in a court filing that tells us anybody's cell phone number. So you've got to register for that stuff. That's why I was asking the question, like, how do I get people to do this stuff? Sorry, I'm talking so fast, but there's a lot. So we also could allow people to register for text messaging, and then we push out the Zoom information via text as well, and all the reminders via text. We use Agile Jury, so our jurors register on a platform through our clerks, which are independent constitutional officers. But what that allowed us to do is we could calibrate the jurors, bring them in, don't bring them in between surges. So we kept trying cases whenever the positivity rate went down, we'd reopen. Then we shut down again, then we reopen, but we could spin on a dime. The other change that we made, and again, some of this stuff is really sensible stuff that you go like, why didn't we do that before? Our jury pool room held 300 people of 25 judges. If they're all trying cases, there's not enough jurors to go around. So we shifted to direct report and required jurors, instead of keeping them all in one big room, not a good idea in the pandemic, to direct reporting to the courtroom. So as a result, I had 2,000 jurors report Monday and Tuesday of this week because we have a lot of trials going on right now. So it amplified our ability to do a vast number of trials without the physical constraints of the jury room. We also have published across every unit of the court, criminal, civil, family, probate, juvenile, what our rules are about. Here's what's remote, here's what's live. If you're remote, you're presumed remote, you can ask to go live. If you're live, you're presumed live, you can ask to go to remote. What's live? Evidentiary hearings and jury trials. Everything else pretty much is presumed to be on Zoom because of the efficiencies. And my job in the system is to try big cases. I've been in a series of 3-4 week trials, and every one of them over the last 2 months has had a witness appear remotely during the course of the trial. And it's worked fine. And the jurors don't mind and don't bat an eye. And I think that's hit most of my high points in my time.
All right. Okay, I'm going to turn to Ms. Chang. You are a member of the American College of Trial Lawyers. I've outlined the 10-figure cases your firm handles. Many of them are time sensitive. I was talking to one of your partners the other day who has a plaintiff who's suffering from cancer, would like to get the case to trial quickly. However, the pandemic hit, and all of a sudden you've got criminal going first and everything kind of pushes down from there. So it's my understanding that the greatest mover of cases is for judges to set firm trial dates and to not move them. So how are you getting trial dates for your clients? Do you have to stand in line? What do you like about the changes? What don't you like about the changes?
Well, first, let me say from the civil side, when we're looking at these cases, and Judge Drummond is correct, we get cases resolved by trial, by settlement, or by some court disposition, right? And when the pandemic hit, I'll tell you, the biggest worry on the civil side was, how are we going to close cases? It's what all judges are worried about. But, right, if you're a disabled individual who has, a case, and you're actually depending upon recovery at some point, do you wait till the pandemic's over? Do you participate in a remote trial, which is where all the courts pivoted? And if you do, what's the guarantee of your due process? What does access to justice actually look like for you if you're participating in in a remote jury trial? And is it going to be a jury trial? Are you going to default to a bench trial? So some of the things that we had to do immediately, because I think that was, at least for trial lawyers in civil cases, the worry was, how do we get disposition of these cases? And let me start with some of the easier things. One of the things our courts did was beef up settlement discussions. I think that private mediation today in the last 3 years has been more florid than it ever has before. Mediators are closing cases and they're doing it by Zoom. So it tells you people are motivated to settle. On the plaintiff side, I'll tell you that we were concerned that insurance companies were going to delay disposition of cases because they could. They could hold on to their money longer. It turns out they're actually incentivized to close their cases as well. And so we did see a lot of cases closed during 2020, even more in 2021, as people kind of came out of their homes a little bit, or at least got into, the timeliness of practicing law again. I think there was a period of time truly in 2020, right, where we were just figuring out how to get up in the morning and what we were going to do for the day if things were shut down and if the grocery store was open. But once we kind of all settled in, I think cases were getting closed. And so that's not really an issue for us anymore. But we were immediately worried about trials. The American Board of Trial Advocates got together. We had a task force of about 20 people from across the country. And the first thing that we did, and did it within a month, was to write out guidelines for having in-person jury trials, because we're focused on, one, trials, that's how you get rid of cases, but two, believing that we are better off having a cross-section of the community decide the case, as opposed to a single neutral arbitrator, for instance, or a single judge as your fact finder. That I would prefer to have, whether it's a group of 6 to 8, or frankly, 9 to 12 in my cases. And the COVID white paper that actually is on the American Board of Trial Advocates website, as I said, we finished it in about a month, and we consulted an infectious disease expert from Berkeley. It was someone that I work with on the Kaiser Oversight Board. And one of the other things I do is make sure that the Kaiser arbitration system works efficiently so that cases are getting disposed of there too, because they're in a private arbitration system. But we consulted that expert about how to handle exhibits, how to handle in-person activities, and that got distributed around the country within a few months, right? So that judges had it available to them as a template for ways in which you can handle, as I say, in-person trials, and give the parties some comfort level that they are still being heard in a way that gets their case disposed of, as I say, fairly. There's been a lot, I think all of us have heard the controversy between how great is a remote trial versus an in-person trial. And I will tell you, I went to Italy last year for 2 weeks. It was one of the most amazing experiences. Why is that better, being there, than watching Italy on TV? Why is that? What's the quality about being there? What teases your senses? What makes you think that's more credible? It's the same thing that happens in a courtroom. And I have to say, the hard thing about being a trial lawyer is you are trying to tell 12 people, in my case, the state court is a jury of 12, plus there are 2 alternates or however many to secure that I don't lose 12. So if I've got 12 people, how do I let them identify and empathize with what happened to, my client and even the defendant in a circumstance? When it happened outside the courtroom, it is remote. It happened 3 years ago. It happened 4 years ago. Now, what we learned from the Derek Chauvin trial is that if you have a video, it's really easy to actually describe what happened. And we saw that video way too many times. I think it showed 20 times in that trial. But, you didn't have to imagine what happened because you saw it. And in our cases, 90, +% of the time, we don't have video. So my job as the advocate is to use picture words, is to use, other illustrative things to show you what happened. Okay, so we're already moving in a, watered down version of what actually happened. Now I'm in a remote setting. Okay, you don't get to see the witnesses. And one of the things we did learn from remote settings, particularly in big business trials and big business depositions, is that you can create your own atmosphere. How much imposter syndrome did you see? I had this conversation with one of my good friends who represents big businesses, and I told her, people can start to use virtual backgrounds to suggest something about themselves that's not true. I can't decorate worth piddly. It is humiliating. You will never see my house on a Zoom. It will be a virtual background that looks immaculately, beautifully decorated by somebody that, looks like they decorated the celebrities' houses. That's not my house. You may have a very, very different impression of me than when I actually show you my barren living room that looks like I'm in a dorm room, because that's the extent of my ability on that. So what are the have and the have-nots? That became the question, I think, for some of us about access to justice. Because when I had that conversation with my good friend who represents big business, in her trial, you know what she did? She had a virtual background that looked professionally done for her expert, and it looked like that guy was in a real live NASA lab. Yes, you're giggling, but there's something wrong with that, because the perception now of this person's credibility has changed than if he just simply had bookshelves behind him, right? And if he was dressed differently. And these are things that when we come into a courthouse, part of the beauty of it is the neutrality of it. You come to the courthouse and it is nobody's house but the government's house. And when you're there, it becomes your house. And we don't get judged by whether it's clean enough, well decorated enough, or any of the enough, because it is enough and it's equal for everybody. And our credibility is based upon those things that we bring to it. And the thing I mentioned about being in Italy, okay, why is that experience more real? Because it is real. And when we're doing it remotely, the ability to be distracted by 15 other things takes away some of the investment that we have in the decisions that we're making for other people. And so these were immediate questions that as trial lawyers, we thought about, how do we make this more fair so that the quality of decision-making isn't taken away by what's faster and cheaper and easier. And that was my biggest fear. And I'll tell you a lot of other trial lawyers too. Hence the reason for the white paper about how to do this in person. Other things, as I said, that we thought about with the availability of exhibits, showing exhibits, because when we show them and we point to them and we're all together, our learning is different. And again, our ability to empathize is different when we're all learning it together, right? I mean, if we think to, I used to teach preschool in those years between college and law school. And, having kids in the room with you, showing them, whatever photographs so they can develop their understanding about things in the world was very different, obviously, when I'm showing them pictures than when I show them real live things. Right. And that's true when we're in a jury trial. If I have real evidence compared to photographs and diagrams, I'm going to use the real evidence. But if we're in a remote setting, there will be nothing about real evidence that is real to you. So again, if my job as the advocate is to make the events come to you as closely to real as it can be. I have to take away these filters that are blocking that. And for me, for many of us who are doing jury trials, Zoom is one of those things that takes it away. That doesn't mean that you have to do them all entirely remote. We always, even before the pandemic, had remote witnesses on some occasions. You know, I've got a witness that, for instance, was going to be traveling and I couldn't get him to trial. So what do? You do a trial deposition, right? You do a trial video recording, or we would do a remote video piece of testimony. So there are opportunities for that. And I think that since it's become more acceptable, it's easier to access some of those. It's not as expensive. You know, when we did a video deposition years ago, it would cost, you know, thousands of dollars because you'd have to find some location that had this remote access, and now it's available to everybody. So some things are easier. We can keep some of those things, but I think it would be a disservice to people to say we should go fully remote in things that really matter. Some people would say there's too many cases. You know, and my response to that would be because in the United States, unlike a lot of other countries, people have a lot of rights. So we get to exercise the protection of those rights. We do. And we are better off more often with lawyers than not having lawyers when you have a serious right that should be defended or should be advocated for. So I would say those are some of the things that we thought about, considered, kept. The other thing that has emerged from this as we talk about judicial discretion. One of the things certainly from the American Board of Trial Advocates and other organizations is the concept of at least give people a choice. Lawyers will know their cases better than the judge ever will, and that's how it should be. If the judge knows the cases better than the lawyers, it's because they've been in court too often. That means there are discovery fights, that means there have been motion fights, and that's a problem. One thing we did find in the pandemic, fewer discovery fights. I do the updates for the Rudder Group book on personal injury. And every year I, update chapter 6 on discovery. And there's usually a ton of cases in the last 2 years, a lot lower appellate decisions on discovery. And I think because we are having fewer discovery fights, because those are things that should be handled by lawyers in a way that is about civility, professionalism, and a good idea about fairness and sharing information. So what we advocated for, at least through these trial organizations, is that don't choose for us. If we're going to do things remote, let the parties choose, because we do know our cases better, and we're not always going to choose in person. Sometimes it's beneficial to our clients for a variety of reasons to do it remotely. Sometimes, the defendant is international. It may not be easy to get a lot of people from Japan. It may not be easy to get people from Korea. It may not be easy to get people, pick any other country where manufacturing is done or goods are in the stream of commerce here in the United States, right? So, people won't default to one or the other. It depends on what their case is about. And so I would advocate here, and have been, that for the judges, don't force remote trials, at least let people choose. And I think I did ask Judge Bailey about this a long time ago, that with Florida, it has to be stipulated. Is that right?
Yeah, in Florida, if you, whatever the presumption is, if you want the other, it's by either stipulation or you've got to appeal to the court. But there are no forced Zoom jury trials.
And my last thought on things we might keep, some of the great things about being able to make this more efficient, online jury questionnaires, if we're going to do that, that's one way to do it. So you eliminate one of the extra days in court, they can fill it out online. Hardships online, and then the rest of it, I think, if it matters, right? There is the old term was don't phone it in. Well, don't phone it in. Show up. And as to the court's budget, what I've told every judge that I've worked with when we've had these conferences is, one way to tell what matters to people is where you spend your time and your money. And if our check ledger doesn't say that we're spending enough money in the courts, we need to put more money there, because people do deserve it. And quality lawyers, as I said, are not going to show up in court that often, because I'm not going to have a bunch of discovery fights or a bunch of motion fights. I filed good pleadings. I have, the answer is good. And you know what? The only time we really should see the judge is in a settlement conference and a pretrial hearing. Maybe there's issues for summary judgment, but I'm also going to say there might be too many summary judgment orders these days.
All right. Well, we're going to move from the courthouse in Florida, clear across the country, to a courthouse in the state of Washington. Judge Williams, you were a trial attorney before taking the bench. In 2021, the Abota chapter awarded you Trial Judge of the Year, not Judge of the Year, but Trial Judge of the Year. So Ms. Chang is in your outer chamber. She wants a trial in person. You have another case which you related to me over a, what, $21 backpack?
$12.
$12 backpack
$12.
involving how many witnesses?
17.
17 witnesses. So how do you triage? Tell us about your pivot and the study you're doing.
Wow. Okay. Well, first, I have to tell you, I am one of 54. And I need to be very clear. I'm not here speaking on behalf of the King County Superior Court. I'm just one of 54. And I'm really proud to be in the trenches where the rubber meets the road. I had the unique experience of being a trial lawyer for a lot of years, but then be in November of 2020, trying, as Jennifer and as Doris and Alex know, trying the very first start to finish fully remote jury trial. And I went into it going, oh, this is never going to work. I was exactly where Doris is. And then we did it. It was not what we thought. That was November of 2020. Since that time frame, I've tried at least 20 fully remote civil jury trials, countless bench trials that have been fully remote. And my colleagues, together, we've tried somewhere between 400 to 500 fully remote jury trials. Now, where does that fit into this discussion? Well, I can share with you my experiences about, and I echo what Judge Bailey said, one size doesn't fit all. There are things that, if only every single one of those unrepresented litigants in a protection order case, in an eviction case, in a debt collection case, if only they could have a Doris Chang, if only. And unfortunately, as you heard from Justice McCormick, I mean, first off, and I got to tell you, there's only one Doris. Let me say that right up front. And if I'm ever in trouble, I know who my first call is. But the reality is we don't have the ability, and nor is the answer simply to increase the number of lawyers. What we have to look at is our processes. We have to look at, for each of the entry points into the system, how do we make those entry points more accessible? How do we eliminate the barriers that allow unrepresented parties, or even parties that are represented? How do we make it so it's easier for them to get their day in court? And then once they're there, how do we procedurally make it so if you're sitting there outside and you have the option, I can settle this, or I have to wait around and I'm missing work and I'm going to get fired. How do we make it so that those individuals can have their day in court? As Mark said, they can have their trial, but it's not going to cost them their job. How do we make it so that jurors don't have to sit around we're exactly the same. It's about 300 people sit around for 2 days waiting for the convenience of the judge and the lawyers. Well, pandemic forced some things on us. It forced us to eliminate gatherings. It forced us to move things. And I heard Justice McCormick use the phrase asynchronous. And it is a wonderful phrase, but there's synchronous and asynchronous, there's live and there's remote. And how do we take away the in-person part so that it can be remote, but we can still have it, we can still get it done without having to force people to come together? And like Judge Bailey, we found that when we brought her, and I'm going to use jurors as an example, when we brought them into this remote environment, first by using the questionnaires that Doris was talking about, where we could, without even having to talk to them, they could just fill out the questionnaire. We could deal with hardships. We could deal with really, really obvious things that they were biased. We could just deal with that without even having to bring them in. And then how do we, instead of bringing them down to the courthouse, make them sure and wait for us, how do we make it so that we can deal with the process of the initial stages of jury selection and then jury selection? Well, we came up with a solution. Is it perfect? Well, no, but then frankly, neither is in person perfect. But we go back to this idea, and here's how I would break this down in terms of what we kind of keep, what we learn, and how we incorporate this in. And it really boils down to this. What are we used to? Look, 200 years, 200 plus years, every time we were in court, every time there was a hearing, there was an argument, it was either submitted one of two ways. Either the lawyer sent in a packet of writing. By the way, you see this? This was the briefing on the motion to file an overlength brief. It was not the overlength brief. That was only this big. This was the briefing on the motion to file the overlength brief. Or lawyers showed up in court. And then they had to present their arguments, and it was an oral process. And we heard some discussion earlier today about that process. Well, you know, when we look at these processes, there's what we're used to. 200 years, we're used to showing up in court, it being in person. We're used to that. We like it. I like it. And I got to tell you, when I have really good lawyers in my courtroom, trying their case, practicing their craft, man, that is a good day. And I miss being in the well. And I like in person. I like it a lot because it's what I'm used to. Then there's what we want. And that is both in the context of what is in the past, what we want, what we're used to, but it's also aspirational. And we've heard some really great discussions about this is what we should aspire to do. There's what we want. And then there's what we need. And we heard Justice McCormick talk about the innovations of how we took what we want aspirationally, not what we're used to so much, what we want aspirationally, and what we need in order for the justice system to function. And it really boils down to, as Alex said, efficiency, access, and fairness, really heavy emphasis on access and fairness. So look, what do we keep? You heard Judge Bailey talk about this idea. We break down the places inside the system where we can use technology and our lessons from pandemic. We can use it to eliminate the barriers to fairness and to access. And then it becomes this balance point in terms of cost and culture. And then there's the things that we may want, but we don't necessarily need them. And Doris and I have had a lot of discussions about this. I've had many discussions with trial lawyers around the country. And invariably, before we get too focused on the idea of jury trials, which is really, I don't think necessarily the focus of where we are with respect to this panel. But when we think about about fairness and access, here would be my observation. Bear in mind, 20 years in the well. I like being in person. I like it a lot. But as a judge who has to make credibility decisions, I will tell you, rarely do I need to see someone from the waist down to be able to make that decision. I've had jurors, and I agree with this, on bench trials, which is frankly, when we're talking about debt collection, we're talking about unlawful detainer evictions, when we're talking about protection orders, we're talking about general family law cases, at least in Washington State, those are bench trials. And I've had jurors and judges tell me, I can see the witnesses better. I can see their micro expressions. And you remember earlier today when David was asked to take his mask off because it was muffled? Well, right now, you're in a courtroom, you're 40 feet away from the person, you cannot see their face, even if they have a transparent mask on and their voice is muffled, even if they have a microphone. I can see them better. I can see when their pupils dilate. I can see when they're looking at something that they're not supposed to. Same thing, by the way, is true for jurors. And I call them out. And I don't let them use virtual backgrounds.
Tell the story about the woman who was driving.
Oh, yeah. Jury selection. And it was hybrid selection. We're in an asbestos trial, so it's hybrid. So I have the lawyers in the courtroom, but she's driving. So she's up and we're at a big conference center. And she's up on this like, those, you know, those big screens they have in auditoriums. So she's driving. And actually at first she was sitting in what looked like a big chair. And then we realized that when she got up and she went to the counter and paid, that she was getting a petty Manny. And then she got in her car and I thought, okay, well, good. She's going to settle down and she, you know, car's quiet place, focus, right? There's, you know, she can, she starts to drive. The lawyers, they just keep going. I'm going, no. I said, ma'am, I need you to pull over. Okay, I'll pull over, Judge. She keeps driving. The lawyers keep going, ma'am, I need you to pull over. Okay, I'll pull over. She keeps driving. Finally, I just said, ma'am, I'm where I'm going to be. I said, I don't care. You will be down here in the courthouse at 3 o'clock. I'm too busy. I'm like, I have marshals. She showed up at 3 and immediately told us about a pre-scheduled trip to someplace that she wasn't quite sure that they'd already paid for, that she couldn't quite tell me how much it cost. And that's why she couldn't serve. The lawyers by this point just wanted to get rid of her, and so she was gone. The story of the $12 backpack speaks to this issue of what courts do, whether it is a location or it's a service. And the $12 backpack, so you remember you guys chuckled when he mentioned, we talked about, it was 3 days. It was a small claims trial. So it was on this report. 3 days. It was in person. 3 days, 17 witnesses. And what it was these essentially a dispute over a backpack that was supposed to be an award when you joined this dance studio. But the backpack, because the girl had to drop out because her grandmother didn't want her going to that dance studio. But she didn't get her backpack. So this is over the $12 backpack. But was it really over a $12 backpack? You know, this was 2 matriarchs in this relatively insular community. And as you may or may not be aware, Seattle is incredibly diverse, but it also has very diverse insular communities. It was 2 matriarchs inside this insular community and their families that were fighting over this. Was it really over a $12 backpack? No. It was over respect. And so I actually, one of our Supreme Court judges just laughed at me and was rather critical of the fact that I took 3 court days to try this case. But when the 2 matriarchs walked out, and understand as they're walking out, their families are trailing behind them. And these are families that would have engaged in some form of non-judicial recognition, you know, street justice. As they walked out, they hugged. That was a good day. That was me doing my job. And that's the service that we deliver. And I think we need to be very careful. When we think about what we need, our service in the justice system, it's not a place. It's not a program. We have KCMS, which is like Court Map. It's not those are the tools. The service, the thing that we give is that day in court, what Doris was talking about, what you heard from so many of our speakers is that it's that day that goes directly to the point of, was I heard today in court? And how we achieve that, well, you know what? I got to tell you, I'm convinced one size does not fit all. It does not. So when Doris shows up in my courtroom, back to your original question, Mark, and she says, I want an in-person trial. My response is going to be, okay, why? What makes this case different than other cases that would normally go into the realm of a remote trial? What makes it like those things? Why? Let's make a decision together. And let's balance the risk that we have of bringing those people into the courtroom versus what we're used to, what we want, what we need. And that's what we've got to do on all of our processes to eliminate those barriers.
All right. Now that we've lit the fuse, let me share a screen before I pitch this next question. Where are we? There we go. talk among yourselves. All right, so the COVID hits, the civil jury project turned to remote advocacy. This is our training video that we sent out. And I'm writing articles. The titled one was "The Long Distance is the Next Best Thing to Being There," touting remote jury selection, saves time in terms of having, instead of 100 people come down to the courthouse and have to find parking, you only have the 12 that get selected. I'm touting this. And all of a sudden, my colleagues at NITA, the National Institute of Trial Advocacy, come out with the white paper on wanting in person. So I am in the center of it. I am in the center of it between both of them. So I'm going to pitch this to the professor. Have we become even more of a patchwork across the nation, where there are some judges I know who will say, I'll never do an in-person voir dire. It's all going to be remote, and then we'll bring them in for an in-person. Other judges will say, no, I'm not comfortable with this. I mean, even in a single courthouse, you could have a patchwork. So folks on the panel, this is the lightning round. I'm going to give you each 2 minutes to state your views on this. And then I'm going to pitch the surprise question to all of you, and we'll take some questions from the audience. So Professor, you're on.
Great. So thank you for the question. So I think what the pandemic moment has given us is awareness of the patchwork that might not have been accessible before. And yes, I think that there are new sources of variation that the pandemic has brought about, but I think that they were all sort of simmering in the first place. We just weren't able to observe them in the sort of the scale we are. So you had mentioned, one example here. So I've been interviewing judges and trial court administrators and clerks and all of these other folks in addition to my document analysis project. So, speaking to a judge in a given courthouse in a given jurisdiction somewhere in America who goes entirely remote, but the person next door never held a remote hearing for the entirety, well, so far in the course of the pandemic. I was speaking with a judge a couple of days ago that said that he did not realize until the pandemic that a different docket in his state did not use e-filing where his did. But he didn't know that until this moment sort of brought that to his attention. So I do think that it is leading to more information seeking on behalf of researchers like me, but then also just sort of like this inter and intra jurisdictional conversation about what those differences might look like. But I also would want to say that we do need more systematic evidence about how the patchwork, like what the relationship between the patchwork and outcomes, or like what we want to measure the consequence of the patchwork might be. Because I do find in other research with Professor Shanahan and our colleagues, Jessica Steinberg and Anna Carpenter, that even if you have a patchwork, and in our case, the patchwork is different levels of guidance and permission given to judges in the way that they can interact with self-represented litigants in the courtroom. There's a wide range of ways that jurisdictions sort of give these rules or things that look like rules to judges in these interactions, but we find that the patchwork still leads to a similar bucket of outcomes. So I think because we don't really have a good sense of patchwork equals what, then I don't know if I could say that justice varies because we need the data to tell that story.
All right. Judge Bailey, I'm going to go to you. Is the justice system in Florida even across the board within the courthouse? Or what are you working on to try to make it so?
So when has the justice system in any state, in any jurisdiction been even? I mean, I'm just going to say that every judge is different, right? Every circuit, every state has great judges, have judges who people are less enthusiastic about. So this is just the overlay, right? It's like Leonard Cohen said, you know, there's cracks in everything, but that's how the light gets in. And what COVID did was COVID lit up a lot of cracks in the system. Now, we are not going to have a universal standard of justice because justice is fundamentally a human proposition when judges are involved. And there are different judges, and they do not work for me. God knows I wish they did. My power comes from moral suasion and parking spots. That is all I have control over. And so what, but I'm going to throw out one other thing. So here's where I think you've got absolute uniformity for the most part among practitioners, mostly among, I think, the unrepresented who are able to articulate their point of view and judges. I don't think motion calendar will ever be live again. Small matters, whatever you call it, where you are, those 5-minute calendars where you had to come down to court, pay a lawyer, if you had a lawyer, to come down to court, to pay $30 to park, to sit there for an hour and watch us in all our brilliance here, whatever the cattle call was, and then reverse it back out, was no longer a cost-effective proposition for the de minimis matters that had to be resolved to get cases to trial. So motion calendar, as far as I can tell, will never be live again and shouldn't be live because they're 5-minute motions. They shouldn't, the matters that are at stake there are not as significant. Cattle call events. Why do we do cattle call events? Those are for the convenience of the court. It's certainly not for the convenience of the unrepresented litigant who is sitting there trying to figure out what's going on with 1,000 other people and can't even hear their case being called. It's not perfect, but in many respects, they have a much better shot at being heard, quite frankly, where it's on Zoom and it's a little more organized than people just milling about a courtroom, I would propose. And then the last thing I'll just observe about all this is, I have spent the past 2 years in this discussion about trials. Trials happen in less than 2% of the cases. And while Doris is right, and despite 2 years of effort, I cannot peel the trial lawyers off of believing that a trial is the lodestar of a case and that cases won't settle unless there's a trial date. It happens in 2% of the cases. They're the crown jewel of democracy. There's nothing better than being in a trial with great lawyers and a great case and great issues. It is 2% of our workload. Justice is not being done in trials. Justice is being done in the myriad of hearings that lead up to trial, or in the many cases that you all are here to talk about, the one and dones, maybe two and dones. And what are we doing with those? And this focus on trials, quite frankly, leads to an appearance of deliberate indifference to the other huge swath of our caseload that is where everybody experiences justice. And we need to take those just as seriously as trials. And we need to have a conversation about, because so many litigants find justice much more accessible remotely, about improving the digital literacy of those who need to participate remotely. Because, you know, if you're working housekeeping at the Marriott, you can't afford to take a day off work and come sit around the courthouse. They're going to make that, if we give them and empower them to make that choice, they're almost always going to choose to do remote if they can do it off their smartphones. So now what we need to do is make sure that they can do it competently and adequately and vector them to the resources ahead of time. So they know about the Zoom app, or they know about the potential defenses, or they know how to upload their paperwork that shows somebody shafted them. Give them those resources in advance to the best of our ability to do so that they have a shot at a fair shake.
All right. Doris, I got in hot water for my remote jury trial article. So I will give you 2 minutes for the final word on that. I'll flip it to Matt for, like to hear about the study for 2 minutes. And then we will launch the surprise question to the audience because as Judge Bailey pointed out, trials are 2%. So let's talk about the other 98% and maybe get some questions.
Well, I mean, I think if you want to talk about the other 98%, which we've heard a lot from, I think, even Judge McCormick about how to run things administratively. So you can look at that 2% as either insignificant or when it comes up, it is really significant because it is only 2%. Right. And I think that's the balance that we're trying to have. As I said, if you're good civil trial lawyers, I should not be occupying the court's time except in few circumstances. Right? A case management conference to make sure things are on time. a pretrial conference to make sure that we're set for trial because we couldn't settle it in the interim. And 98% of cases do settle. So that's something to think about. Just as a rebuttal, because as plaintiff's work that I do, I always get rebuttal. I'm going to suggest that if the default from judges is you shouldn't be in person, if that's the default, I'm actually going to suggest that you think again about why human beings matter to each other and why relationships matter and why when we're in person, we develop a greater connection with one another than when we have a love-long relationship by phone. It's not the same thing. What information are we getting when we're in person? What dialogue are we getting? Not verbal ones, but nonverbal ones that tell us something about each other and why we find each other valuable. And that is the reason, not because we've always done it that way, but because when you come into each other's presence, there is a different weight in the way that we understand each other, love each other, or hate each other, or are indifferent. And those things matter.
All right, thank you. Judge Williams.
The study that he's talking about, and we've been kind of really hammering on this idea of remote appearance versus in-person appearance. And, I really need to circle back to the data, and which is the study that Mark's talking about, studies plural actually. And I have to circle back to the fact that, well, at the end of the day, one size does not fit all. There's where you are in the process matters. What you're doing in the process matters. The study that Mark was referring to, and as I said, there's two studies, kind of a third. The study he's referring to is in King County, similar to what Mr. Zimmerman suggested earlier. We did a survey of all litigants, court staff, lawyers that had appeared before the court during pandemic. And part of what we asked was we wanted to know about familiarity and what do they want in the future. This actually tracked with the National Center for State Courts study as it related to how people viewed virtual proceedings in terms of fairness, in terms of convenience, in terms of whether or not they wanted to continue. And that study showed overwhelmingly the parties were overwhelmingly in favor of remote proceedings. This isn't about jury trials. This is just about proceedings. They were overwhelming for exactly the reasons that Judge Bailey said, overwhelmingly. Weirdly enough, and there was a differentiation on the step, the lawyers were also overwhelmingly supportive of the idea of remote appearances. Again, there was some differences, but even on jury trials, the lawyers that had done them, there was positive viewpoints on that. The most negative viewpoint of remote proceedings, court staff. Why? As you heard Judge McCormick say, you heard Judge, it takes a lot to set it up. It's hard on our end. And it's expensive because there's personnel, but there's also equipment, which fortunately we were able to get some grants. So we actually now have like monitors in the courtroom. But so that study showed that for lawyers, interesting demographic point just on remote proceedings generally. But this also applies to the extent that we want to talk about jury trials anymore. It applies to that. There is this fascinating break point in terms of comfort level with remote proceedings at 11 years of practice. 11 years of practice or less, very comfortable, very positive. 11 years of practice or more, a significant deviation in terms of, and you heard Judge Bailey, Justice McCormick talk about that. There's also been a study that was done, and this was on jurors. It was done on their reaction to the remote process, but it was also done on the diversity of the jury pools. That study, there was initial results published, which showed a significant increase in diversity. The study has been pulled back because of some algorithmic corrections. Anecdotally, I can report as it relates to jury pools and jury selection, and I do keep track of in my court. Last count, I think I've been keeping track of about 8,000 different jurors, and I compared it back against both census data as well as against the prior study that was done on jurors that actually showed up. a significant increase in diversity of our jury pool. And I attribute this to the very reason that Judge Bailey said, and it's just this: look, the digital divide of the 1980s and the 1990s, it doesn't look the same as it did
Right.
then. The digital divide now is more about, I'm working at a minimum wage job and you want me to give up 2 days, or I can sit in my break room with my smartphone,
Depending on your data plan.
depending upon your data plan. And if you can't sit in the break room, well, you know what? You can come down to the courthouse. We got free Wi-Fi.
Yeah.
Or there's, you can always go to Starbucks. So, so those are the studies that Mark was talking about. But, I got to circle right back to this, and this has to do with the elimination of the entry points. Remember when Professor Fred was talking about the work that he's doing? The elimination of those, not entry points, the elimination of the barriers to the entry and to the fulfilling of the process. Remember that with the data he was talking about? And you remember the question I asked him about that? Because for us, it's about tools. We know there are barriers. We have to figure out, how do we eliminate those barriers without creating new ones? And ultimately, that's the thing. So it's not this or that. Most of the time, it's this and that. And it's not just one thing. It's one size does not fit all. I can't say that enough. So, thank you, Mark.
All right, we have about 12 minutes left. I'll frame this up very quickly. So people, when they ask me, why did you retire? I always say G.K. Chester. And he wrote a 2-page article called The 12 Men. And I know you can't read that, but I think I remember what it was. He was summoned for jury duty in his small town in England. For jury selection, they just do alphabetically. They took all the C's. So everybody who had the last name C showed up. And he talked about this jury trial where this woman was accused of neglecting her children. And he said, I suspected that she too had been neglected her entire life. And he writes this wonderful sentence: I have never stood so close to pain and never so far away from pessimism. And before I show you this next thing, I'll throw this out. Do we really need judges to decide the other 98%? Or can we get others to help with the 98%? And I would read this to the judge. When I was presiding judge, I would read this to our judges like every 3 months. They hated it. And the horrible thing about all legal officials, even the best, about all judges, magistrates, barristers, detectives, and policemen, is not that they are wicked. Some of them are good. Not that they are stupid. Several of them are quite intelligent. It is simply that they have gotten used to it. And I never wanted to get used to it. Strictly, they do not see the prisoner in the dock. All they see is the usual man in the usual place. So I just want to throw this out that, for debt collection, we have people who are non-lawyers to help them navigate debt collection. Eviction cases, landlord-tenant cases to help these people through, to tell them, perhaps what a judge may or may not do. I've always thought we ought to have jury trials in divorce cases. When I decide custody issues, it would be very easy for them to say, oh, well, the judge is biased, or biased against men, or biased against women. I would love to have 12 people tell this couple who've spent tens of thousands of dollars and years litigating that you're right, you're wrong. So I'll throw it open for questions. Any comments about this? We'll let the panelists field the questions.
I do have one comment that we haven't really mentioned for overall civil justice innovation. The cost minimization of remote hearings, it's had the most significant effect on cost reduction for those that can't afford lawyers of any innovation in, ever, just ever.
And sadly, it also levels the playing field of expertise. I got to throw that in. I do a lot of work in countries that are trying to implement the jury process, trying to figure out what their culturally specific jury process is going to look like. And it always amazes me when I talk to laypersons in those countries, they are horrified at the idea that something as important as a case, a legal case, could be surrendered to civilians. And it always strikes me, especially given our culturally specific system of justice, which is not monolithic, it has thousands of culturally specific justice systems around the United States. We accept this is our norm. This is what we're used to. This is an integral part of who we are because of those rights that Doris mentioned earlier. And when we think about this idea of injecting and kind of separating out, well, what do we give to, what do we let a judge do? What do we have someone who is a layperson? How do we balance the idea of whoever we bring in it has the potential to be biased versus a person who is ostensibly been vetted and trained in the context of this? You know, there's a balance there. I mean, the reality is, I think Mark's absolutely right. I think that there are places where whether it is AI, and I was recently at a conference in Istanbul in which the students there were participants, they were just fascinated. We need to turn this over to AI. AI can make these decisions. AI, and I'm just kind of going, let's work through what that algorithm looks like. And let's think about what that flow chart and decision tree is going to look like before you start throwing AI out as your solution. Before you start throwing out something where we have an individual who, again, ostensibly is trained. But, you know, in our system right now, we actually do already have that sort of dichotomy. Now, maybe it's a time for us to take a look at it and do some polishing on it. Figure out, okay, these are the things that you want your judge doing. These are the things that you want a jury doing. These are the things that, yeah, you know what, this needs to be pushed into an asynchronous process, like the one that the justice presented to us. Maybe it is.
And I would offer this. I think we live in really interesting times. And certainly the review for adequacy of paperwork and documentation can be done by trained personnel. I am extraordinarily hesitant in the delicate and fragile time in which we find our democracy to suggest that the idea that a judge is ultimately responsible for the justice outcome of the case before him or her can be effectively delegated in this moment when the rule of law is being so fundamentally challenged. It's a worthy conversation, but it's a conversation that I think I'm a little nervous to have right now. And if we can't, quite frankly, teach those, because that, I mean, listen to all the discussion today about we need to educate judges to do this, we need to educate judges to do that, we need to educate judges to do that. If we don't have the judges educated to do some of these things, and I will tell you that, look at the National Center website in the materials, the robust education on conducting procedurally fair remote hearings and the amount of study that's undergone about remote hearings, about how they take typically somewhat longer, to about 25% longer, because the reason why judges are nervous about it and people with more than 11 years is because we're having to teach people about technology and we have to Google how to use our iPhones. So those are all really important points. But I think the question of what the role of judges in society is a really fraught question in the year of our Lord 2023. So,
This
I
ties
believe
right
we do
back-
have a question. We do have a question.
Can I just tie one thing in real quick? Real quick, less than 15 seconds. This goes right back to that difference between elected and appointed. The judges, we were given authority by the people. How we exercise, there's a difference between here's the checklist. This has already been done for you. And okay, this now is an automated process. This now is being handled. So apologies. Sorry.
Well, I was just, there's a lot of eloquence on this panel. But I guess, Doris, your remarks about love and humanity and, visiting Italy kind of stuck with me. And I kind of wanted to see if we could surface what maybe is the sharp disagreement here about whether people buy that
or whether the advantages of the remote technology trump that. Or I just wonder if anybody wants to try to rebut directly what Doris had to say about Italy and love.
So I'll give you this observation. I think that there are some real barriers to remote, we're doing live, we do all our jury trials live. And I don't necessarily think remote jury trials are a bad thing. I think they face two challenges. I think, first of all, the shared experience of not wanting to be there, first of all, for potential panel members and sitting through the trial together is in very rough form, a team building exercise par excellence. So by the time they go to deliberate on that case, these people have built a bond, and I can't, at this point in time, my imagination fails me as to how to replicate that bond in remote. So you just get a different democratic function in terms of jury deliberations. The second aspect of it is there is a ritual to coming to court. Everybody in this room who's a lawyer, who's ever walked into the courthouse feels that moment when you're walking into the courthouse. It feels different. You don't really replicate that on Zoom. It sort of feels a little bit like, somebody may get voted off the island. So trying to figure out how to replicate the ritual aspects of court without coming off like, frankly, a jackass. I mean, nobody should be playing fanfare for the common man when the judge shows up on Zoom. All rise seems really stupid when we all sit in front of a computer. But those are two real fundamental challenges that I don't think we figured out good ways to overcome yet, although I think the work going on in King County is extraordinary in that regard. And at the end of the day, remember what we were trying to figure out in that moment is how to keep things going during a pandemic without killing anybody.
I'll add one more, I'm overruling you this.
Yeah, yes, sir.
Is that anecdotally, some jurors say they feel more comfortable answering voir dire questions in the comfort of their home or at work. So it may be that Doris gets a more honest answer when they're in a comfortable setting, but then can have them in front of her for the in-person.
There are times, as I said, when you may want a remote trial. And having had an arbitration, for instance, where we did half of it remote, there were some benefits to it that I appreciated. I'm not saying it's all bad, but I think you as the lawyer, as I said, have to make good decisions for your client. So I'm going to get back on my soapbox for one moment about love and something about the rule of law, because there's something we have to understand about that intersection, right? The rule of law is there's an accountability. We have a system of accountability where we believe our laws are just, they're consistent with international human rights, and that they're independently adjudicated. So that's all part of due process. And if we truly believe that, then let me come back for a moment, because we're in the law school setting here, and I truly believe this for all of us. And what Judge Bailey said about that ritual and all of that, it is a privilege to carry somebody else's burden. When we all decided to be lawyers, it was because we believed in people, not because we believed in, artificial intelligence or big business or something else. We believe fundamentally in people, and to advocate for people to carry their burden. As a lawyer, we should always advocate for the most impactful way that we can speak the truth of our client, because we're not speaking for ourselves. I'm speaking for somebody else. That's a really big burden. And if I do that well, if I do my craft well, then I want everything that is best and most impactful from my client. And sometimes it is remote, sometimes it is technology, and sometimes it is not. And that is my pitch for having that recognition and not being completely, oppositional to one thing or the other. I mean, we just have to recognize what's fundamentally important to us to function in a rule of law that makes sense. And that, by the way, answers my question that you had about what's the role of judges.
All right. Well, Matt, I cut you off. We are out of time. If you can top that for eloquence, I'll give you 20 seconds.
I use the Darth Vader theme.
Nobody says it better.
There you go, that's the difference.
All right. Thank you all.